Welcome, everyone, to the Sussman conversation about the disappearing civil jury trial. I am Jeff Rosen, and I have the great privilege of heading this wonderful institution, the National Constitution Center in Philadelphia, which has a mandate from Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And what we have the opportunity to do tonight, thanks to Ellen Sussman in this wonderful program, is to delve into a provision of the Bill of Rights that many of us are less familiar with than we are with the First Amendment and the Fourth Amendment, and that is the Seventh Amendment to the U.S. Constitution. And we are going to ask, why is it that the civil jury trial, which represented 20% of all trials in 1930, now represents only 2% of federal trials and less than 1% of state trials? It really is a disappearing right. And we're going to discuss why that happened and whether it's a good thing and whether, if anything, we should do something about that. But let's begin, as always, with the text of the Constitution, and let's begin, if possible, with this beautiful new edition of the Constitution from the National Constitution Center, with a completely thrilling new introduction by yours truly and David Rubenstein about the relationship that Ellen Sussman mentioned between the Declaration, the Constitution, and the Bill of Rights. The introduction tries to explain how the rights that were promised in the Declaration are implicit in the Constitution and were finally codified in the Bill of Rights. So let's turn to the Seventh Amendment. I can do some of them by heart, like the Fourth, but the fact that I cannot do the Seventh suggests that it is less familiar to me, anyway. And I can find it right here. Here it is. In suits at common law, where the value in controversy shall exceed $20, this is one of the two places in the Constitution that a dollar amount is actually specified. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. Okay, to begin our discussion, we have our honoree, one of the great lawyers of the United States of America and one of America's most passionate defenders of the civil jury trial, and that is Steve Susman. In addition to his extraordinary work as a plaintiff's attorney and litigator, where he's represented plaintiffs and defendants ranging from the Northrop case in the suit against McDonnell Douglas, House Speaker Jim Wright, the Hunt brothers, he's just had the greatest of all civil trials of the past generation. Steve is a passionate defender of this disappearing right. He's created a new program at NYU Law School to explore the value of civil juries. Steve, what did the framers have in mind when they wrote those words? And if you were a delegate at the Constitutional Convention today, would you argue that the same word should be inscribed in the Constitution?
Well, it is clear that the Revolution and the Constitution and the Bill of Rights were very much bound up with this idea of trial by jury. It is the only right, not free speech, not carrying weapons, nothing, not equal protection, not due process. Trial by jury is the only right that is mentioned both in the Declaration of Independence as a grievance that the king has deprived us of trial by jury, mentioned in Article 3 of the Constitution, and the subject of 3 of the first 10 amendments known as the Bill of Rights. Amendment number 5 guarantees the right to a grand jury. Amendment 6, the right to a jury trial in a criminal case. And Article 7, the right to a jury trial to be preserved in a civil case. It was all about jury trials. If you read the debates of the Constitutional Convention and the Federalist Papers, what you find is that the reason we have a Bill of Rights today at all is because our founding fathers who got together to write the Constitution in 1787 did not include in the first go-around a right to civil jury trial. And the anti-federalists, the southern states in particular, were very much opposed to even ratifying the Constitution unless the Federalists promised that a Bill of Rights would be passed, which contained the right to a jury trial. So this was a strong tradition. It goes back 800 years for Anglo-Saxon people. And the colonists, the founders, felt that this was very important. They felt that juries were necessary to protect them from an overreaching central government, from corrupt or biased judges, from a lot of it was economics, because the jurors were, the idea of jurors were that they would protect debtors from having to pay their creditors. There was a lot of that going on because, so I just think that you got to have the history to know they were very concerned about their juries. Every state constitution today, except two, contain a right to jury trial. Every state constitution written between 1776 and 1787 contained the right to a jury trial in civil cases. So before we get rid of it, we need to think about what we are doing and consider whether this is a right that maybe is worth keeping. But I do think, Jeffrey, your question is fair. If you were writing a constitution today, would you insert in it a constitutional right for trial by jury? And I come out, I very much argue the side of course you would. Why is a jury, the name of this program is Truth Finding and Victim Compensation. So I think there is no better way to find the truth than to have a jury of 12 people, a cross-section of the community, diverse people, 12 ears, 12 eyes, 12 hearts, 12 brains are better than one. And sure, there are good judges and there are fair judges, but not all judges are good. And when you keep in mind that in this country, 2/3 of the judges are elected in partisan elections, it becomes important that we keep the jury to protect us and to compensate victims when there is some form of wrongdoing. All the empirical research shows that almost without exception, judges who have tried jury trials think that the jury gets it right. Lawyers who have lost jury trials think that the jury gets it right. Even though you lose a case, in your heart of hearts, you say, I deserve to lose. And the entire mock trial, jury simulation industry, which is built up in this country now, where you bring in a group of citizens off the street and in a day you present a case to them, a fact pattern. That convinces me that the juries get it right, watching them, because there you can watch them actually deliberate. You watch them behind one-way glass deliberate, or you watch them on video deliberate. And when you see them deliberate and when you hear the reports that they give of their deliberations, they are very conscientious. The second thing I would say is that a cross-section of people, you are more likely to get someone with more expertise in everything but the law than you will from a single judge. You get lawyers on juries, you get accountants on juries, economists, scientists. You get a very high quality of juror, particularly if you figure out how to make trials shorter, which is something that the bar and the bench has got to figure out how to do. Then juries are representative of the community. People are more willing to accept their verdicts. So the jury gives a legitimacy. A jury also, when you talk about truth finding. Truth finding usually involves who's telling the truth. Juries are much better in identifying who's credible, who's honest, who's being decent and fair and candid on the witness stand than judges are. Judges may be better in applying the law, and that is their job under our system. Jurors are told, you got to listen to the judge for the law, but the facts you find, and the Seventh Amendment says, once you find those facts, no other court can second guess you. That's an important, our founders put a lot of faith in the ability of a group of citizens to find facts. And the amendment on its face says that they're so good at juries are so good at doing it that no other court or jury can second guess what the jury has found. There's a very important role that juries play. Jury service is one of the highest manifestations of being a citizen. Whenever any underprivileged or minority group has fought for its rights, whether it be blacks or women, the fight always begins with the right to serve on the jury. Isn't that funny? I mean, you go to YouTube and Google jury service and you see there's a lot of fun made about how people try to avoid jury service with all these excuses. But in fact, the people who serve really do become better citizens. And I suspect that the next Supreme Court case on same-sex, on whether you can discriminate against people because of their sexual preference, may well deal with whether a lawyer can exercise a peremptory challenge against a potential juror because they are homosexual. The law is very clear, you can't do it on racial grounds or gender grounds. So it's important, and the empirical research that's been done on that is that people who serve on juries are much more likely to vote than other people. They're much more likely to pay their taxes than other people. It makes them better citizens. And then the final point I say is that, judges, again, think about they're elected judges. We live in a citizens united world where judges they get elected by raising money, and there are no limits. And there have been cases in this country where big corporate interests have sought to buy Supreme Court justices. And that doesn't cost much, and it certainly doesn't cost much to buy a trial judge. And by I say buy them, I say just mean give money to them so that when you appear before them as a litigant, they remember who you are. I think to protect the average victim, you need to have a jury. You can't rely on a judge. The Founding Fathers believed that judges could be corrupted, they could be bribed. You know who the judge is in advance. You don't know who those 12 jurors are. You can't go fix the jury. So for those reasons, I think if I were writing a constitution today in this country, I would insert a right to trial by jury in civil cases.
Thank you, Justice Sussman, for that superb opening statement. That deserves a round of applause. It's now my great pleasure to introduce Bert Rein. Bert, after having clerked for Justice Harlan, went on to one of the most distinguished careers as a constitutional litigator and Supreme Court advocate of our time. He's had recent victories in important cases like the Shelby County case, where the court imposed limits on the Voting Rights Act, and the court has just agreed to take up a case that he is involved in, Fisher versus the University of Texas, which next year may decide the future of affirmative action. Bert, Justice Sussman just made a pretty comprehensive case for the civil jury trial. He began with history, and he said at the time of the framing, people relied on civil juries to enforce other rights in the Bill of Rights, like the Fourth Amendment right against unreasonable searches and seizures that protected us against an overreaching government. And he said civil juries remain relevant today because they have legitimacy, they're good at finding facts, and they're good for the citizens who serve on it. They're a kind of public school of democracy. I want to ask, if you were at the Constitutional Convention, would you vote for the Seventh Amendment? And if not, why?
First, just on the point of history, if you think about the way juries originated in England, they were in a world in which the king was absolute. He had absolute power. He appointed all the officials, including the judges. There was no independent judiciary. So the only check on that was to ensure that groups of citizens, particularly in criminal matters, could hold the authority to say, we know the facts, we have sworn to ascertain the facts, we're familiar, we're members of the community with the people involved, we have the best ability to figure out what's true and not true. And so to offset the absolute power of the king, you develop the jury. And of course, right up through the Revolution, the Americas, the United States, is under the jurisdiction of the king, and the king continues to assert absolute power. So the judiciary was not independent and unreliable. And when we have in the Constitution is a separation of powers in which we have an independent judiciary, and that makes a big difference in context. So I think we can't read the history as totally one-sided. You are in 1787 reacting to a past with one set of characteristics that may not be true today. And I think I just say that as a prelude. I don't think history commands us or counsels us to institute a Seventh Amendment if we didn't have one. And I certainly accept we do have one. And I think in criminal cases, because you're sanctioning people and you're bringing the weight of the community against them, then I think the jury has a role in legitimizing criminal penalty. You shouldn't have to be punished unless there's a consensus that you committed the act that's subject to punishment. Civil trials are different, they're very varied, lots of things happen in civil trials. So turning just to civil trials and leaving aside for a moment things like the Fourth Amendment, where they're adjuncts of the criminal system. I mean, you do have some of it civilly, but in subpoena matters, the judges decide them anyway, so they're really not the protection of the jury. Why should we not look at jury trials as the be-all and end-all? First of all, what I call a macro issue, the system would break down. If you look at the number of disputes, civil or criminal, that get resolved outside the province of trial, that's almost a necessary element of our system. If we tried all of those to juries, all of us would be sitting on juries continuously. It would become our occupation. It can't happen. It won't happen because society cannot afford to do it that way. So there's a cost to the civil system. What are the costs? Well, you have to bring people in to sit on the jury. And many of these people feel they're being ousted from their occupations, their daily lives, they're being disrupted, and they feel that it's an undue imposition. And especially because we bring in many more people than ever sit on a civil jury. So many people spend time waiting around to see if they'll be on a panel and whether they'll be impaneled in the petty jury. And they don't come away with that good positive feeling. They come away feeling a lousy $30 or whatever I'm given is no recompense for disrupting my life. And then, because of that, we have to have procedures to command them to come, to chase them if they don't come, and all of this is not free of cost. The system is not cost-free. It imposes substantial cost. It's not like where you could round up the peasants, the serfs in England and say, you'd like a day off from the field, come in and be a juror. So, I mean, that's one practical consideration. A jury trial imposes costs on the court system. You have to have people to bring in the panels, to ensure that people show up when they're called. You have to have the same judge sitting through the trial as if he were trying the case, because he can't walk off the bench and say, folks, this is all yours. He may not pay a lot of attention to the testimony, but he should. So you have all of the same costs that you'd have in a civil system, which is prevalent all over the world, except really here, maybe a little bit in Australia, Canada, they have a few civil jury trials. England, they have them for libel. But basically, we are unique in this. And so that's another cost that really does matter. Then, how about from the point of view of the litigants? Well, they're going to litigate their cases anyway. They're going to have discovery, no matter who's going to adjudicate it. But some of the mechanisms that we have developed, like jury experts, sitting around, psychologists, new occupation, now sitting around figuring out what clues you might have to how somebody would react. So our theory is, on the one hand, it should be a cross-section of the community, and they should, bring the community's wisdom to bear. But all trial lawyers know you move heaven and earth to make sure that jury is a community of people who basically agree with you or sympathize with your cause. So you have it in pre-jury selection so that you can get clues as to what kind of thing might appeal to this group of people. If you get to voir dire, you're going to push to see that you get people who are favorable. During a jury trial, you have tracking. You get a group of people, you pay them to listen to the same thing, to tell you, is it going over well with the audience? It's like instant Nielsen. This is not cost-free. That's one reason people worry about a jury trial, because you build up the costs. So I think, we can't run a system where jury trial is universal. It won't work. It's impossible. So then the question becomes, if you have it, and it can be, let's say you find a class of cases in which it's the stakes are big enough, and the clash over facts, what happened in the world is big enough. How do you distinguish that group of cases? How do you decide what goes to a jury? Should it be in the hands of the litigants? Should it be in the hands of the court? There may be a better way to sort out the jury cases from the non-jury cases. And just on what I call the micro level, assuming here's the case, is it better to give it to a judge or a jury? I think the sources of controversy over that are, you have the statistics, and Steve stated, that pretty much judges and juries see the case the same way. Well, it's a two-edged sword. If you're not getting any different result from the jury, why are we spending all this money and time and effort to have one? If basically you get agreement. It's not always universally true, but it's true in 85% of the cases. What's the numbers show? Second, if you go to the key to the jury, in colonial times, it was a theory that's called nullification. The jury could decide, rule of law or not, we are not doing this. We are drawing the line. These are the king's rules and we don't like them. And the classic case always taught in civics is the John Peter Singer trial. You bring him up for libel because he is, insulting the king. And the king's judges are about to put him away. The jury says, no, we're not going to do that. We're walking out of here. And he's walking out of here. This is a nullification of the law. Now, nullification is controversial in itself when you have an independent judiciary and when you have a legislature, elected legislature, an elected executive. It's a little bit different from having a king who, rules by divine right. So to what extent juries decide cases on factors that you would not say are part of the legal framework, but really part of their community inclinations, that's a tough question. You might like it, you might not like it, but it is different, and it does give an opportunity that doesn't exist in a system where judges at least are sworn to and will try to apply legal rules and say the results should be dictated by the rules. Now, I think that when you try a case, there are two kinds of facts that become involved, and particularly because of the many new remedies we've invented, the many new laws we've invented that are not just simple whodunit. There are the historic facts. What happened? And there can be disputes about what happened, who said what to whom, who drove a car at what speed. These are historic, and I think juries have common sense and probably would agree with judges most of the time about who's saying it credibly, who's telling the truth, whose story holds together. But we also have many cases dependent on what I would call predictive facts. They're theories about the world. They're either scientific controversies, they're economic controversies, and academically we've developed many new techniques to evaluate them. And now you call in 12 people who may or may not have ever heard of any of these techniques, and you say, folks, you're going to see two economists up here, they have PhDs, they're not lying because they don't know anything except what their theories are, and they're going to show you their regression models, and you're going to figure out whether the price is being charged were the result of a conspiracy or just result of the way the markets work. And good luck. Do we really think that you can get an evaluation of those kinds of issues? You have in drug liability cases, the issue is a particular chemical substance capable of causing a certain kind of injury. And this is something that, you know, if you look at the development of drugs in the FDA and the scrutiny by expert panels, you could debate for years. But the jury is told, you got to decide one way or the other, up or down. You can't say maybe. You're going to vote. So it's a very different kind of system, and whether, considering the kinds of questions we bring to court, whether that makes sense to have juries decide them is another question. Remember, at the time of the Constitution, experts were not allowed to testify in court. They were just not allowed. And in the middle of the 1800s, they came in the criminal process where you had the stuff like, you know, handprints and footprints and things like that, where you needed an expert, but they've now universalized. Almost no case starts without some kind of expert if he can get in, and you know, they become the kind of narrators of the story. People use them, and quite effectively, to do more than convey their expertise. They're allowed to draw conclusions, not conclusions of law, but they're allowed to speak to ultimate issues. So they become very influential. They weren't known at the time of the Seventh Amendment. And whether you would see the system differently given the way trials are conducted, I mean, I think that's another very difficult question. And we've seen judges grapple with those kinds of expert issues and find great difficulty. And the one other thing that I think that leads to is the question of time. Because when cases are tried to a judge, and Steve will say this is a deficiency, the judge doesn't decide at the moment. He goes back. He can look at the transcripts. He can look at the exhibits. And if he needs to think about it, he can take a month to think about it, sometimes more. He's not told, you're going to be locked up until you decide. Juries are told, basically, you better decide or we're going to keep you locked up for a while. And so that instantaneous kind of reaction, which may be very good for sorting out conflicting versions of real events in the past, may not be the way to sort out more difficult controversies that are theoretically dependent. So the last thing I'd say, being the devil incarnate, is that what we're seeing is kind of a historic conservative liberal pull and tug, because at the time of the Constitution, the conservative forces who were trying to enforce debts were not necessarily on the same side. And what you're tugging between is the application of rules of law as a predominant way to decide controversies versus the application of human judgment, community consensus can modify the law. So when we say we're a government of laws, not men, if you have a Seventh Amendment, that's only partially true, because you turn over to men, and I don't mean this only men, women, whoever, the job and the opportunity to modify the application of law. So I think in that situation, I wouldn't pass the Seventh Amendment as it stands today, and I think very hard about how to determine whether there is and should be a class of cases in which it's amenable, and also how in the course of those cases the issues could be allocated between judge and jury, because they always are.
Thank you so much for that opening statement. A round of applause for Justice Rein. What a pleasure to introduce Ken Feinberg to mediate between these two positions, because Ken Feinberg is in fact the nation's leading mediator and champion of alternative dispute resolutions. In his remarkable career, he has been Special Master of the 9/11 Victims Fund and was appointed by Attorney General Ashcroft and administered that extraordinary operation. He also administered the $20 billion fund created by British Petroleum for victims of the spill. He's assisted the Virginia Tech president in giving gift donations to the victims of the on-campus shooting. In short, he has had more experience than anyone else in administering huge and complex alternatives to the civil jury system. Ken, you've heard the arguments on both sides. I want to ask, first, tell us what it was like to administer the 9/11 Victims Fund. How did you put a monetary value on those lives? And is something like the 9/11 Victims Fund or the BP compensation fund a plausible alternative to the civil jury system?
Well, the last question's the easiest. these funds that I administer are a precedent for nothing, for nothing. You will see them as aberrations, 3 in 15 years. The 9/11 fund created by Congress 13 days after the attacks. If Congress had waited 2 more weeks, it wouldn't have created this type of fund. BP oil spill, BP walked into the White House, saw President Obama, walked out, and announced we will create, up front, no trials, a $20 billion fund. $20 billion to compensate all the victims of the oil spill. I received 1,200,000 claims from 50 states. I got 15 claims from Colorado. I didn't know the oil had got to Colorado. Alaska, 35 foreign countries, Sweden, Norway. Build it and they will come. So these programs are not a threat to the trials. They are not a precedent. And it's important that they not be a precedent. The 9/11 Victim Compensation Fund was absolutely the right thing to do after those attacks. Sound public policy. The country wanted to show the world we take care of our own. It worked. 97% of all eligible families that lost a loved one in the World Trade Center, the airplanes, the Pentagon, came into the fund. Taxpayer money. Taxpayer money. Don't ever do it again like that. Don't ever create a fund like that again. You'll never see it again. You should have read some of the emails I got during my administration of the 9/11 fund. Dear Mr. Feinberg, my son died in Oklahoma City. Where's my check? Dear Mr. Feinberg, I don't get it. I don't get it. My daughter died in the basement of the World Trade Center in the original 1993 attacks committed by the very same type of people. Why aren't I eligible? And it wasn't just terrorism, you see. Dear Mr. Feinberg, you got to explain something to me. Last year, my wife saved 3 little girls from drowning in the Mississippi River, and then she drowned a heroine. Where's my check? Bad things happen to good people every day in this country. You don't have a 9/11 fund. There was no 9/11 fund after Katrina, you see, or after tornadoes or forest fires or earthquakes. That's not America, these funds. And to delegate all of this authority, President Bush, Ken, I want you to do the 9/11 fund. No committees, no appeals, no second guessing, you decide. Well, that's not the Constitution. That's not checks and balances. I can see why Steve Susman would be very concerned about that, frankly. Every one of these, President Obama with the BP oil spill. Ken, great job. Thank you. On behalf of the American people, you got out in 16 months, $6.5 billion to people who suffered economic harm because of that oil spill. Great, great. All that was a handshake between BP and the President of the United States. No laws, no regulations, except what I set up. Now, that's not the Constitution, and that's not America. I get involved when policymakers decide, very rare, we got to think out of the box. Steve Susman notwithstanding. For this, no, Steve's right on a lot of what he says. And even if he isn't right, he invited me. I can't, you know. The fact of the matter is, policymakers, I don't decide these programs. Policymakers do. Congress, the White House, General Motors, they decide. Let's set up a fund. So they call me. They want to avoid the cost of litigation. They want to avoid the inefficiencies and delays of litigation. I'm paying people in 60 days. They want the certainty. Victims want certainty. These programs are all voluntary. No one has to come in and take the money. Everybody does. 9/11, 97% took it. BP, 92% took it. GM, we're going to finish this month. The ignition switches, 99% take the money. It's there. Come in and take the money. But my final point, why do people come into these programs? Well, Mark Muller is here somewhere in this audience. Mark Muller represented 350 people in 9/11, families. Ask Mark Muller, but it seems that 97% we must be doing something right when we set up these programs. But just remember, I am not here to wage another view here between Bert and Steve. I think the trial system, whether you like it or don't like it, it's here to stay. It's such part of our heritage, such part of the fabric of our country, that if you think you're going to change the Seventh Amendment, or if you think that you're going to somehow, as a matter of constitutional policy, undercut the role of the jury in our society, you are dreaming. You're tilting at windmills. A better question for these two eminent law clerks. A better question for Steve and Bert. Why aren't there more trials? Now that's a separate question. That's not a constitutional convention question. That's what's wrong with our system today that more people don't take advantage of the Seventh Amendment. But what I do, folks, believe me, it is better studied not in a law seminar, but in a history class, because what I do is no threat to our legal system, to our lawyers, or to our judges. These are rare, rare aberrations, and they should be seen as aberrations, not to be encouraged. There we are.
Superb. Well, the question is fairly met, and Steve, I think that Ken's question is excellent. The Seventh Amendment is here to stay, but why is it that so few people take advantage of it? Tell us about the history that led those numbers to decline from 20% in 1930 to less than 1% today, and what would you do to increase the numbers and have more people take advantage of their Seventh Amendment right?
Well, I think that trial lawyers and judges have done a very bad job. The question is always, what is the competing dispute resolutions? People are always going to have disputes. You're going to have a service. What is litigation competing with? And if you're whatever you're selling, if your product is too expensive or not deemed to be safe, the competitor is going to win out. That's what's happened with arbitration. Arbitration is private dispute resolution. I think it's horrible that we have gone to so much private dispute resolution, just as I think it would be horrible if every school in the country were a private school. There's a room for private schools, but there's plenty of room for public schools. Arbitration does not create any precedent. There's no stare decisis. There's no law built up. These are paid private judges. And so I think the lawyers have been at fault and the judges because they have, in a way, hobbled juries in finding the truth. The jury's not supposed to read anything in the paper or look at what's on the internet. That's totally contrary to what it used to be. A jury of your peers was supposed to come to court because they knew something about the case. Now we are looking for the lowest denominator on juries. Trials go on forever so that the judges allow them to go on for weeks. So instead of getting a day in court, you get a month in court. And the consequence of that is the only people who can serve on juries are people who are unemployed or retired. So that's not good. The jury instructions on the law are totally incomprehensible, although they're written nominally in English. You can't possibly, a lawyer can't sit there and listen. Felix Frankfurter couldn't listen to a jury charge in a patent or securities case and tell you what it meant. So there's a lot of things I read this book called A Trial by Jury, written by a Princeton professor of the history of science, and every time they asked a question to the judge said he wouldn't answer it. You don't get written instructions, a copy of the written instructions. You're not allowed to ask questions. You're not allowed to discuss the case. Everything you can do to make it difficult for people to comprehend, we have done to our jury, and that's got to change. So there's a lot that's wrong with the jury. And so in any event, a lot of it, obviously, I think originates with the business community that in the 80s began thinking that all litigation was bad. And that's when we had tort reform and lawsuit abuse reform and a lot of changes in the law to keep people from going to court. That was considered to be a bad thing. And so I think, and as a result, we now have, you cannot buy any goods or services without agreeing to give up your right not only to a jury trial, but to any kind of trial. Every time you click on the internet, I tried to get in with my iPhone this week to the iTunes store, and I had to, it said there are new terms and conditions. Check here if you want to go further. If you didn't check, you didn't get in. So I said, I'm going to see what these terms and conditions are. 73-page contract. I'm not kidding you. Anyone who has an iPhone can see the 73-page contract. Now, no one can read that on an iPhone or a laptop, but I'm sure in there somewhere is that I have waived my right to file to jury trial for limited myself to damages that I'm going to recover. And the Supreme Court has blessed this. So in all these, if you are a consumer, a borrower, a patient, an employee, every time you sign a contract, you give up your right to trial by jury, to access to the public justice system. That needs to be changed, badly. Because, and it's really interesting, if you are a criminal or accused of a crime and want to give up a jury trial, the judge brings you before the bench and for 2 hours explains to you, you have a lawyer here and you got the right to a trial, and if you don't exercise it, this might happen. Do you understand? Do you speak English? Do you have, it makes the accused speak in court so that we know that there has been a voluntary, knowing waiver of the right under the Sixth Amendment to a trial by jury in a criminal case. Why don't we do that under the Seventh Amendment? Instead, we have the Supreme Court sanctioning these click-through contracts and contracts of adhesion, which people give up their Seventh Amendment right without even knowing that they give it up. A study done by the Consumer Protection Finance Bureau this March, the results were published. 90% of the people who are subject to a mandatory arbitration clause aren't even aware that they are subject to that they have lost their right to go to court. And so the public generally does not understand that you are losing your right to trial by jury because you are voluntarily giving it up every time you buy anything. And big business is overreaching. Corporate America is hiding behind these arbitration clauses to avoid facing a jury. So there are a lot of reasons why we are losing. I think the arbitration is one reason. I think another problem is, 8 of the 9 Supreme Court justices have never tried a jury case. So that's a lot different than in the day when I was clerking for the court. Justice Black was a trial lawyer in Alabama. He wanted to protect the jury because he had done it before. He knew about jury trials. But now you deal, 8 of the 9 have never, and all they see are these outlier verdicts. The coffee case, that's reported in the popular media. Even that gets misreported. And so there's all this popular lore about juries doing bad things, doing extreme things, and about the expense. And if we got rid of it, maybe we could save the Seventh Amendment.
Great. Well, we have about 10 minutes left for your questions, and I have to warn you, ladies and gentlemen, that as at any constitutional conversation here at the Aspen Institute, there's going to be a vote at the end of our discussion, and you are going to have to decide whether or not, if you were a delegate at the Constitutional Convention, you would vote for the Seventh Amendment today. So frame your questions to inform that vote, and you're welcome to ask them of any of our panelists. Gary Lauder. The mic is coming down right now.
Earlier, jury nullification was mentioned. This is an esoteric thing which I've heard could be used efficaciously by those who know about it. Could any of you elaborate on that?
I'm happy to do it in the moderator role, and Bert, I'll describe it, and then I want you to amplify on a point you made. So jury nullification was at the core of the most important cases about shaping the meaning of the First and Fourth Amendment. Bert and Steve mentioned the Zenger trial, where John Peter Zenger is a printer who publishes seditious libel criticizing the king. He's indicted, he's dead to rights. He can't argue that he didn't criticize the king, because under British law, the greater the truth, the worse the offense. And by all accounts, he should have been found guilty, but a civil jury, refused to convict him of seditious libel because they didn't think that seditious libel was appropriate in a free society. And in a similar case under the Fourth Amendment, John Wilkes is accused of printing anonymous pamphlets criticizing the king. He's accused of seditious libel. He objects that the general warrant that authorized the search of his house is invalid because it didn't specify the place to be searched or the thing to be seized. And again, a jury gives him £1,000, a McDonald's coffee-like verdict, because they believe that these general warrants, although authorized by the law of the time, violated the natural rights of English people. So those are two examples of jurors refusing to convict people in civil trials of laws that they considered unjust, even though according to the laws of the time they were in fact guilty. Bert, do you really believe, given that history at the core of our Constitution, the mere fact that we're now a democracy and no longer ruled by a king means that civil juries should not retain the right to nullify what they consider are unjust laws?
Well, you know, I think, as you said, that context of nullification is you have an arbitrary authority, which may be, in your view, totally unjust. You've had no voice in the shaping of those laws, and so suddenly you're up against them. And the king has said, you know, I know what seditious libel is, and clearly I've proven it here. And what the jury is saying is, we're not going to accept that. We had no role in it. We don't agree with it. Steve's talking about debtors. It's quite clear that one of the things was, okay, they might have a right at law, the creditors, to collect, but it's unfair and it's too deleterious to our economy, and hell no. You know, so it's making law. But why do you want 12 people arbitrarily chosen to make law? We have a democratic system. So it's a little bit different, and that's the only point I was making about nullification. But everybody wants to nullify something. You have a ruling from the Supreme Court on gay marriage. You've got governors who say, not here, not here. We don't want to obey the law. You had massive resistance to desegregation. Those are all sort of nullifications. The popular will says, damn the torpedoes, full steam ahead, we're going to do it our way. So it's not so easy to support a theory of nullification when your alternative is a democratic process that can change those laws. And Steve talked about arbitration. These arbitration rulings are under a federal law. You could change that law. Congress could change the Federal Arbitration Act and say, no more of this. But it's also true that the number of jury trials was declining very rapidly before the widespread application of arbitration and before Concepcion. So you can't explain it. It's a wonderful jury type argument. Here's something that'll get you mad, but it really has nothing to do with it. That's one of the risks of a jury trial.
We have time for a few more questions. Yes, sir, in the middle.
Yes, Mr. Sussman, have you considered how elimination of consensual arbitration as a remedy might affect some parts of the economy, would you work as an investment advisor if you know that a jury rather than arbitrators are going to decide whether a disappointed investor gets his or her money back? And are you equally passionate in defending the right of defendants to jury trials in class action settings once there's been a determination that there are greater common issues? Many issues of such as causation and damages are taken away from a jury, and the defendant doesn't really have a right to a jury trial.
Well, the answer to I don't think it had that much of an effect on the economy. Arbitration has only become big in the last decade. I mean, it's something rather new. And our economy was doing fine before then. Frankly, I have two things I want to make clear. If parties are equally bargaining, they can resolve to settle their dispute in any way they want, including arbitration, arm wrestling, casting lots. I don't have any problem with that. I have the problem when I am asked, when I want to buy something that I can't even read, I got to check something off and give up my right. That's kind of what I have a problem with. I don't really have too much of a problem with your investment advisor situation, because if I don't want to go to FINRA with my disputes against you, I'd go find another investment advisor who doesn't require me to do that. I assume I could do that. In any event, that's my view on that.
Great. Meryl Chertoff.
All right, so I want to get back to the law school classroom a little bit. So back in the day, when he was a law professor, Guido Calabresi of Yale developed a theory called the economic theory of tort. And I'd like to hear from each of our speakers your view of the interaction between the economic theory of tort and the right to a jury trial.
I'll start with Ken. Do you want to explain what the economic theory of tort is, or shall Meryl refresh our memory about Guido's great theory? Okay. Well, just to be...
Let's start with Steve.
I honestly don't know what that means.
I think I have an idea.
University of Texas Law School.
Yeah, and I didn't go to Yale either, but I think I have a fair understanding. I mean, you're talking about what role does tort adjudication play in society? And, in some societies, let's take Scandinavia. You have a social contract with the state as a whole, with the people as a whole. So the idea is if something adverse happens to you, it's a public responsibility to care for you. So that in those societies, attributing blame, tort, is really secondary. You reserve certain possibilities because you not only want to identify how to help the person who's injured or harmed, you want to at least create a culpability outside the criminal system. In the US, we don't have a pervasive social system. We just got comprehensive health insurance a while ago. So in that sense, tort is a vehicle for people compensating themselves for injury as well as attributing blame, and it depends on a blame theory. Now, you don't have to have a blame theory. I mean, California developed rules, which I think Calabresi looked at and said, if you put a dangerous commodity, it's going to injure somebody, you ought to build that into the price. It's a matter of, where does the social relief come from? Those kinds of things, kind of take away this question of finding blame in each case. It says you want to reserve blame for cases in which there's been extraordinarily bad conduct. And there are a great many arguments for that kind of a system where you price the cost of it into it. But if everything's on price and you're building in an inefficient mechanism for the transfers, there's two problems. One, that will come back in the price. And two, it's random. Because if you think of people similarly situated and similarly injured in a tort system, somebody thinks about going to a lawyer, another person doesn't think about going to a lawyer. You don't have, in Ken's sense, social justice. In his kinds of administration, Everybody's entitled, and it's relatively easy. A lot of people fear the courts. They don't want to go to court. They don't want to waste their time. So a tort system is in some way a crapshoot. It's random. And I would say the greatest advantage of the jury system is the interim effect. Everybody's scared of the jury, and that's why you can settle more cases. Whether they're well settled or not is another question, but having a big fear factor is not a bad, it's like nuclear deterrence, right? If you keep messing around, you might have a nuclear holocaust, therefore don't do it. I think the jury trial and maybe some of the myths around it lead to that kind of behavior, and maybe they're in their own way the cause of the fact that we don't have jury trials, because people don't want to take that risk.
Ken, now that Bert has reminded us what the economic theory of tort is, did you apply it on the 9/11 Commission?
No, you see, we do an end run on theories of tort. We invite people voluntarily to come into a system which doesn't affix blame, doesn't deter, compensates. That's all it does. It compensates individual victims. Now, in 9/11, 94 people, 3%, decided voluntarily not to come in to my program. And I met with them, and I said to each one, why aren't you coming into a program that will compensate you in 60 days with an average award, tax-free, average award of $2 million for a death claim? And some would say, no, I lost my wife at the World Trade Center. She would want me to sue to make the airline safer. See, that's Calabrese. To make the airline safer. I said to her, you're not going to make the airline safer by suing. The airlines are as safe as they're going to be without your lawsuit. But even if you believe that a lawsuit will help make the airline safe, let the other 93 people sue. Why don't you come into the program? You're piling on. You're the 94th litigant. Let 93 people litigate to make the airline safer. Come in and get your money. Well, some did, some didn't. But that's how I answer Merrill's question.
Ken, without the threat of a civil jury trial, would BP or GM ever put up that kind of fund?
I doubt it.
So there you go.
I doubt it. I doubt that very, very much.
And this question's for Bert. Bert, tell me of a kind of case, any kind of civil case that you're aware of, where the biggest issue, the one that amounts to the most money, is not intent. Isn't that I have never tried a case where intent is not the key issue. Just like it was the issue in the Obamacare Supreme Court case. What did the Congress intend? What did the parties intend? Who better than a jury of your peers at ascertaining what people really mean and think and intend? Well, that's not technical.
If you're talking about intent, you can think about a patent case. What's the intent in a patent case? Because the law is absolute.
Willfulness.
Willfulness is not imperative. You don't have to prove willfulness to win. You have to prove it for certain additional rewards. But all you've got to prove is you infringe the claims of the patent. And if you infringe the claims, you're liable. And I think you know that better than anybody else. So you're being too cute with me, Steve. But anyway. In a lot of big ticket cases, intent is not the issue. Even if you said a pharmaceutical liability case, did they really intend to injure somebody? If the warning was inadequate, was it inadequate because they really wanted, to protect the drug? Sometimes yes, sometimes no, but intent is not necessary. In fact, it doesn't have to be proven. Is the warning objectively sufficient or not sufficient? So there are a great many cases where intent is not an element. Conventional tort, common law tort, the answer is yes, it's often an element, but certainly we've moved away from that for economic reasons, Merrill. I mean, a lot of cases are just absolute liability or strict liability, and intent has nothing to do with it.
See, these programs, like 9/11, have nothing to do with liability? Nothing. They have nothing to do really, if you really think about it, they have nothing to do with justice. They have very little to do with fairness, these programs. What's just and fair if you're giving someone $2 million who lost a son in an airplane? They're all about mercy, empathy, and they're very, very rare. And no one ever comes to me in any of these programs and says thank you, gratitude, appreciation. Don't expect it. When I do this, brace yourself. Just brace yourself. No, because you're going to really, it's debilitating. You do it, it's debilitating. But you get the money out the door and you move on, and it's mercy because it really isn't fairness and it isn't justice.
Ladies and gentlemen, the Sussman conversation, like a Supreme Court argument, must end on time, and it is time for our vote. You have heard the best arguments for and against preserving the Seventh Amendment civil jury system. And the question on the floor is, if you were a delegate at the Constitutional Convention, would you vote in favor of the Seventh Amendment or not? Everyone who would vote in favor of the Seventh Amendment, please raise.
What's the date? What's the date? We vote now or we vote
now? Everyone who is in favor raises his or her hand. And everyone who would vote against, please raise his or her hand. The Seventh Amendment wins. Please join me in thanking our panelists.